to ask if there's one person that has an opening statement.
Yes, I have an opening statement.
Thank you. Go ahead.
Okay, thank you. And initially, I'd like to acknowledge all the victims of domestic violence in Australia, particularly Nathan Cattins and his family, who had his daughter recently murdered by their mother in 2019. The family of Daniel Surtees, who was burned alive by his wife in 2019. James McLeod, whose 4 children were murdered by their mother in May 2019. Aaron Cockman and his family, whose 4 children and ex-wife were murdered by their grandfather in 2018. The family of Darren Reed, who was burned alive by his partner in 2016. The Good family, who had their 3 children murdered by their mother in 2015. The Thaiday family, who had 8 children murdered by their mother in 2014. And I'd like to acknowledge the Clark and Baxter family, who are left with the deaths of their children and grandchildren because of Rowan Baxter's actions, and ultimately the reason why I guess we're here is discussing coercive control behaviour. I mention these names, the names of these victims, as a reminder to you, our elected leaders and policymakers, that domestic violence victims are not defined by their gender, and that your job when making recommendations to government on new laws is to do so with the goal of ensuring all victims of family and domestic violence are provided with protection regardless of their gender. I'd like to remind the committee that the Australian Brotherhood of Fathers has been talking about coercive controlling behaviour for the last 7 years publicly. We've been running a campaign called Not Your Right, which talks specifically about coercive controlling behaviour post-separation, and we thank the committee for an opportunity to speak today.
Thank you very much. It's very helpful. And Mr. Jones, I assume that, do you have an opening statement or is that on the top? Yeah. Thank you. I'll take it as read. Members, colleagues, questions?
Look, I thank you for your detailed submission. It's very extensive. I'm not going to ask any questions other than to congratulate you on your gender neutral submission. It is recognised and should be recognised and reinforced that unfortunately domestic violence touches upon all members of society, whether they be male or female, and it should be acknowledged and recognised that perpetrators and offenders are both male and female as well. So I think I have no questions because your submission speaks to itself as far as I'm concerned, but I congratulate you on taking a pragmatic approach to your submission. Thank you.
Thank you.
Thank you.
Thank you.
Colleagues, any other additional questions?
I don't have a question. I'm just going to
Just for those colleagues online, thank you. Sorry, that's okay. No problem. So, Deputy Chair, Trishore.
Thanks, Chair. I'm just going to make a comment that in the main, victims are defined by their gender. Over 90% of victims are women and children. But that's not to say that there aren't victims from time to time that are men. Thank you.
Thank you. That's great to hear from you. Our job here is vast, and we do appreciate the opportunity to hear from a wide variety of stakeholders, and appreciate your input and also the detailed submission that you have made, which is helpful to flag up with committee members. I just wanted to ask you about the current framework and whether you think that there are immediate steps that could be taken in relation to coercive control and the gathering of evidence that might assist to gather that evidence and put it before courts and judiciary at the early stages through perhaps the ABF system or other ways that in your experience in your work might assist.
Did you want to have a go?
I'm sure Michael's got something to say.
Michael, did you want to have a go?
Except just to identify the fact that gathering evidence, I think, is going to be difficult under the proposed legislation. And obviously we have both the UK and Scotland to turn to in relation to the implementation of the legislation, the potential elements and construction of it, and how it has actually been effectively applied within those jurisdictions. I think the general commentators state that within the UK and Scotland, it cannot be considered to be unconditional success. I think, and there's various reasons for that, which I'll briefly talk to, but it's worth noting that for every single unsuccessful conviction, there are obviously wasted resources or applied resources. There's a cost to society, and there's a loss for the opportunity to assign those resources and that funding to address other crimes. The forces within the UK have stated that coercive control charges have shown to be very hard to achieve and challenging to prove. I think within the first 2.5 years of the legislation within Scotland and the UK, the majority of cases were dropped without a charge. In our submission, we've got statistics such as 12 out of England's 29 police forces have brought fewer than one charge under the legislation per 100,000 people under their jurisdiction. There's data in relation to 33 police forces within England and Wales across 2016-2018 showing that there were 7,000 odd arrests, but only 1,100 cases had resulted in someone being charged. And that the Home Office said there'd only been 235 successful convictions since the law was introduced. What that represents is a phenomenal burden to both police forces, police investigative resources, and also the administration the justice system. Need I point out the burden in relation to domestic violence on our judicial and justice systems across the country. By way of example, in 2018 in New South Wales, there were some 33,000 domestic violence orders applied for, and that's increasing about 10% per year. So the cost to administer justice in relation to some of these legislations is incredibly high. The prosecution rate and the very low prosecution rate may indicate deficiencies with the offence, difficulties of the police in proving the cases. It may also indicate that there is a pressing of false and malicious charges that are never going to succeed. We know within Australia in some jurisdictions there's a pro-prosecution policy in relation to domestic violence. We think that is disproportionately harmful because it means the burden falls upon the accused to attempt to defend themselves. So we know with dealing with many men that as soon as they are charged with an offence, even if that offence has no chance of succeeding, they're already incredibly burdened in relation to the costs to defend themselves against a potential criminal charge and criminal conviction. They also suffer phenomenal stress and duress in going through that process when in many cases those charges were never going to succeed. We know that police frequently state that they take a pro-prosecution approach and they let the courts sort it out. That's, we believe, is not the way justice should occur. We also note in the UK and Scotland that the custodial sentence for those sent to prison under the new laws was 17 months or less, and the average amount of compensation paid to victims was £413. So definitely a lot of work needs to be done in relation to how the offence is going to be worded and how it's going to be potentially administered and prosecuted by police, and whether there is a cost-benefit analysis associated with that.
I think to add to that as well, if we look at the current system, where a temporary order can be made or a final order can be made for that matter without evidence being produced other than hearsay evidence, we believe that it will further impact negatively on innocent people who for no fault of their own other than having a relationship that's ended, they're finding themselves before the courts, restricted access to their children, and facing penalties that are a result of a relationship ending. We see it on a daily basis. We see the impact of coercive control predominantly on men, because that's the work we do. We work with men and dealing with DV and family law matters, and the courts, the police, under the current system, are failing those men, and we see it as systemic discrimination. It's really concerning for us, particularly when the private members bill was made initially, that they were talking about penalties of up to 10 years. And I can assure you, we want to hold perpetrators accountable. If men or women are doing the wrong thing in their relationships and harming their partners and their children, they absolutely should be held accountable. But I don't think this is the vehicle to make that happen. I think the focus should be intervention and prevention, and taking care of people when they come out of relationships to ensure that they're safe and protected, rather than trying to generate penalties post-separation, again, without producing any tangible evidence.
Yes, and poorly drafted legislation and poorly administered legislation may just be another additional avenue for abusers to weaponise such courses of action in tandem with the family court actions. We've spoken extensively in relation to how actions in relation to domestic violence tend to go hand in hand with family court actions in relation to both property and parenting matters. We see it as a potential opportunity for a continuation of abusive control through system abuse. We consider it to be domestic violence in itself. We've also extensively written in our submission how there are significant issues in relation to false allegations, particularly where there's no ramifications for false allegations within applications in relation to, say, for instance, ABOs or allegations within the family court. Without a doubt, an action under coercive control will no doubt have a family court action in parallel.
If I can just jump in as well, I can talk from personal experience in relation to my family law practice. I've been a practitioner for over 12 years now, predominantly with family law. And my experience with the current domestic violence legislation is that, as Lee said, it is blatantly discriminatory. You could have the exact same set of facts presented to a magistrate, and if it was a male applicant, it would be dealt with differently to if it was a female applicant. Just in terms of your question in relation to the current evidence gathering, what we're seeing happen quite frequently is a DVO application is made by a female. There are allegations made in there. I'm not talking this, on occasions there is actual some independent evidence being there might be injuries, there might be text messages, things like that. They don't need to have those things for an interim order to be made. They can be just allegations of things that have been said. They go on to court, they'll file the application on a day, they'll generally be in front of the magistrate on that day, an order be made ex parte without the other party being even aware of it. And then a lot of the time an ouster order is made where police show up at the house and then the respondent is ousted from the property. We see this all the time. The vast majority of women's applications are heard ex parte and an order is made straight away, very often with ouster orders. Very rarely, when we've got a male applicant, orders heard ex parte. Generally, if they were filed today, they'll get a court date in a couple of weeks' time, and then the respondent can come and give their side of the story. In our view, that should take place at all times, particularly in circumstances where you've got children involved and where the applicant is asking for an ouster order where somebody can be taken from their house and be given no type of accommodation, no kind of support or any other kind of support from the government at that time. There's a massive difference there, and I see it weekly.
Of grave concern also that the...
Please stop you there. Thank you very much. I appreciate your response. If you'd like to provide further information, you're most welcome to do so in writing. And appreciate your day-to-day experience. They are wide issues and wide questions. We have, however, terms of reference, we have to deal with these questions that we've been given. So I'm going to ask you just to take a question on notice and provide an answer to me in writing on notice, and I believe my colleague has the same, and then I have two questions from members during video conference. So if you could just take on notice, and I take on board your comments about the challenges, and I appreciate your contribution in that regard. And I just wanted to ask if you take on notice discussion paper question number 8, which I think talks to some of the issues you've raised, which is how might the challenges of creating an offensive coercive control be overcome? And I appreciate your raising those challenges, and I just wanted to see, I may not have read closely enough, but what your suggestions might be for meeting some of those challenges from the perspective that you've brought. The committee staff will provide those questions to you, and I'll just briefly ask my colleague Abigail Boyd to let you know her question on notice, and then I'll go to Justin Francis.
Thank you, Chair. And thank you to our witnesses for appearing today. Part of our job as a committee is to not only receive submissions and give people a chance to have their say, but also to test the veracity of the evidence that we've received. Given the previous history with Australian Brotherhood of Fathers, I don't know how I want to say this in a respectful way, but coming up with figures based on anecdotal evidence instead of statistics. I refer in particular to the 21 deaths a week campaign, which you ran, I believe, a few years ago, which was based entirely on a conversation somebody had with a paramedic, I believe, and was referred to as anecdotal, but then the quote was, "We're waiting for somebody to come and tell us it's wrong." you quote a lot of things in your submission. Some of them have footnotes, there's a whole bunch that don't. There's one, for example, saying the consensus is that men comprise 1/3 of all victims. I don't think there is consensus. My question on notice is, could you please go through, and every time you make an assertion about particular statistics, if you could back that up with actual evidence, so that we can understand the veracity of the evidence in the submission, that would be fantastic. Thank you.
Yeah, no problem. So thank you for that question. Just to add to that, so the 20, yeah, happy to, but just in regards to the comments referencing the 21 Fathers campaign, we actually still run that campaign because it is a significant concern for us. That campaign was started because of media reports by some of the advocates that have been working with men for the last 40 years, Lone Fathers Association. We produced the campaign because the numbers that were being talked about, between 3 and 5 men a day taking their lives because of family law matters, we took as quite a serious subject. And we produced the campaign as an awareness campaign to ideally have government research the topic and produce some sort of evidence that would give us a better idea of the impact of suicide in men dealing with family separation and the policies that we're currently working on. I think
Thank you, Mr. Erickson. I appreciate that. And what I'm going to do is ask you, I'm just conscious of time, and I've got 2 members who'd like to ask you questions. If you'd like to provide that further information, please do so on notice in writing to us. The members invited you to do that, and we'd love to hear your answer in that regard. So thank you for that. I'm going to hand now to right over to online, Justin Clancy.
Thanks, Chair, and gentlemen, thanks for your submission and for being here today. In terms of the elements of the offence, and appreciate your contribution in that regard, I want to ask you to expand on page 21 of your submission in terms of course of conduct frequency. You touch upon that 2 occasions you would consider too low a threshold, and you propose a reference to an ongoing and sustained pattern of behaviour. So I ask you to expand on that and how you might define that ongoing and sustained pattern. But then secondly, the last paragraph on that page, you say a large number of crimes are expressive crimes, and that in some way those that are influenced by alcohol should be distinguished from patterns of behaviour. So I just ask you to expand on that as well, please. Thank you.
Michael, did you want to expand on that? I think we've lost Michael, so can we take that those questions on notice?
Sorry, I've got that. I'm unmuted. Sorry about that. In the UK and Scotland, one of the elements of offence is in relation to the course of conduct or frequency, and I believe that's proposed to be an element in the Australian offence. It has been suggested that maybe it could be as little as 2 particular actions. We're suggesting that 2 actions in relation to an offence of this type would probably be quite inadequate. Whilst not actually identifying an exact number, we think it must actually be a series or a pattern of offences that comprises coercive control to an extent where it might be provable at law. The reason being that certainly in our experience, both professionally and legally, and also in an analysis of the research, which is actually extensively referenced in our document, we will provide a summary of that, all of the most significant resources in the world, is that a lot of domestic violence is situational, a lot of it is reciprocal, a lot of it is explicable in terms of the interaction between the individuals involved, and that a lot of it is expressive. That is, it's in relation to duress, stresses, in other triggers such as mental health issues, as I said, incident-related drug or alcohol abuse or other psychological disturbances. And in many cases, as I said, it's reciprocal, so there's fault on behalf of both parties. That's in the research. That's also in the JUDCOM surveys from 20 years ago. So we believe that trying to identify something as little as 2 particular actions is going to be woefully inadequate to distinguish between what are expressive or situational crimes or mutual actions versus an ongoing pattern of asymmetrical control.
Thanks, gentlemen. Michael, in that regard, so I suppose, appreciating your comment about the threshold, then in some way that an expressive crime could be, so could be, in some way considered differently, or I find that I suppose it's a part that I find challenging to suggest that might have say alcohol as it could in some way be ameliorating aspect. So, but don't need to answer that. That's just a thought there. But thanks, gentlemen. Thanks, Chair.
Thank you very much, Justin. And another one of our colleagues online, Steph, please get us in.
Yes, I am, Chair. Thank you very much. Thank you very much for your submission, gentlemen, and for appearing before us today. My question is in two parts. Then I refer you to page 13 of your submission. Under section 3B, paragraph, 2 in that section, you state the current system is too easily weaponised to cause harm to good people, and often the children are caught up within it. The system also little power to prevent or respond to the committing of tragic violent offences. We argue it may even perpetuate such. And then the following paragraph being the enacting of coercive control within the current paradigm may be just yet another weapon that causes harm and fails to protect. Are you referring, when you refer to the quote current system unquote, is it the ABDO system that you are referring to? And regardless, could the current legislative regime governing ADVOs better address coercive and controlling behaviour, and if so, how?
Did you want to make comment on that one?
Probably Michael go first. Michael?
By current system, I'm referring to all of the laws, legislation, policies and procedures that have been put into place to address domestic violence historically and at present. So it does include the family courts, the federal courts, the state jurisdictions in both their civil and criminal jurisdictions. So it's the entire regime or paradigm and legislative regime that's been in place now for decades. One of our key issues is that I don't believe it's possible to demonstrate with any degree of veracity that has had an impact upon reducing domestic violence within our community, within our homes, or reducing domestic violence tragedies within our community. There's no correlation between the spend, the application of new legislation, and a downturn in relation to domestic violence rates. So we believe that at present, it can't be demonstrated the current system is working. And we have argued in our documents and in substantial other literature that in fact we believe the current system is failing in many ways, not only to reduce violence, but also it may be acting to cause, perpetuate and escalate violence through multiple pathways. One of those is in relation to obviously false allegations, and the fact that the current systems can too easily be accessed and weaponised to be used in family court actions. In our document under false allegations, we express extensively in relation to our issues around that. We also in our document talk about how the system currently is we believe, causing more harm than good to society.
I think just to add to that as well, that it's not just our comments and our evidence that it's suggesting that the current system is failing vulnerable Australians. It's also the view of many in the legal industry and also the judiciary. Unfortunately, with the judiciary, it's only when they retire is that we hear their true opinion on how the system is failing victims. And I think the one that sticks in my mind is I think
Magistrate on the Gold Coast.
On the Gold Coast, yeah, his name escapes me for the minute. But he raised concerns that our domestic violence laws that were produced to provide a shield for vulnerable families are now being used as a sword. Where there are children involved and in parenting matters. We see on a daily basis how the current system is failing victims and failing to interact appropriately with perpetrators, where you can consent without admission to a protection order and basically get away with it scot-free after committing acts because there hasn't been a finding of fact against you. I think it's just a ridiculous method to use nationally in the chance of reducing the instances of domestic violence, We've spent close to $1 billion over the last 10 years with no significant changes in the rates of domestic violence in our society. Wouldn't that suggest that we've got it wrong and that we need to, and I'm thinking, while we support coercive control laws and we would like to see perpetrators held accountable, frankly, I think it's just another tool to be used against men who are left in a position where they're restricted access to their children, and the system is used to enable violence against them.
The retiring magistrate that we referred to was Magistrate Ron Kilner of the Southport Magistrates Court. We also made reference to retiring Family Court Justice David Collier. Their comments are in our document. We've also made extensive reference to both the JudCom surveys within Queensland and New South Wales, which are incredibly insightful across a whole spectrum of issues in relation to the domestic violence industry. One can only ask why decades later those surveys haven't been rerun.
I think that's a really valid point for the committee to consider, that the judiciary was screened in regards to their views on the laws and the use of allegations in domestic violence matters, yet those same surveys have stopped. And I think it corresponds with what we see as a failure of the policy that state and federal government has delivered relevant to domestic violence.
Currently, both in relation to the ADVO.
Yep, if you've got further comments, I appreciate, sorry, we are just limited in time, and we would invite you to put those further comments in writing. Just mindful that the committee here does have terms of reference that we are required to. That's our purpose, and that's what
I understand. Just in regards to your just in regards to the terms of reference. Sorry, can I just a quick question? In regards to your terms of reference, if you're producing legislation in New South Wales, underneath is it the COAG agreement between states on domestic violence? What decisions you make, or what laws are passed in New South Wales potentially affect the entire country? Would that be a true statement?
Thank you very much. We're going to finish that